Record going. Let me make sure that everybody is muted. Everyone is muted, right?
Thank you so much. See you around. Sorry to help. Thanks, everybody.
It's all you.
Can you move about?
You can move about. The camera's on you. The slideshow's showing for most of the people as like their big screen, but they'll still be able to see you in the small one.
Okay.
So if you're moving around, it's great.
Very good.
If you write anything on the board, yeah, appreciate it. All right. Everybody, congratulations. We are now at the time where you're going to start your first law class. So I'm going to introduce Professor Cohen, who teaches Introduction to U.S. Law with us, and I'll turn it over to him.
I appreciate it. Thank you so much. I am Peter Cohen. I teach Intro to U.S. Law. I've been doing so for the last several years, both in the JM program and the LLM program. I also teach appellate brief writing to second-year law students in the JD program. And so, if I understand it correctly, this is both a JM and an LLM joint orientation. How many LLMs are here? Shout out your countries of origin. Where are you from? Pakistan.
Saudi Arabia.
Where?
Saudi Arabia.
Saudi Arabia? Where else?
Brazil.
Brazil. Where else?
Portugal.
Portugal.
Japan.
Okay. Well, welcome. Yes.
Russia.
Where?
Russia.
Russian. My wife was born in Russia. So welcome to this orientation. All right. Okay. Very pleased to teach this class and have for several years now. And the reasons why is because it not only gives me sort of an opportunity to meet students, both American-born and not American-born, who are very interested in a dynamic, ever-changing, and I mean ever-changing subject, including very recent Supreme Court decisions, as we'll see, which has redrawn the landscape on many of the issues, at least on several of the issues that we'll be discussing. So it not only gives me an opportunity to meet students from all walks of life, but it also gives me an opportunity to teach in subjects that I have been immersed in, that have been very much a part of my life for going on 40 years. So very pleased to teach this class for those reasons. And welcome. I'm looking forward to it, as the graphic says, and I hope you are too. What I'd like to touch upon today is a couple of things. This is an orientation, so obviously it's not going to get into detail about subject matter. Some of it might. But who I am briefly, I am the teacher of this course. I think you have a right to know who I am, since we'll be together for several weeks. And also, and more importantly, to describe sort of the various themes or understandings, appreciations, hopefully, that students will walk away with by the end of the course. I always like to begin the course by letting students know what I hope you take away at the very end of it. And we'll be touching upon some of those themes today. And then talk about more of the sort of the logistics of the class, syllabus, plan, grading, exams, and stuff like that. Does that sound okay? So first, I wouldn't mind sort of going over sort of an overview of the subject, or at least many of the themes, and then getting more into the areas of logistics of the course. Okay. For me, I've been practicing for more years than I'm caring to admit. For nearly 40 years now. I'm a partner at a Virginia law firm, and I've been there for 20, 25 years. I've drawn back from the practice to give me an opportunity to teach, so I'm kind of in semi-retirement, but I'm not. I'm kind of an in-house consultant with my firm, where I still like to do those aspects of law that I enjoy most, which is research and writing, which is one of the reasons why I love teaching appellate brief writing in the second years in the JD program. We do all civil litigation, not criminal, but on the civil side, and we specialize in employment law. And employment law, you would never know this, but in the area of employment, it raises all sorts of claims litigable claims that you wouldn't ordinarily associate with the workplace, and many of which we'll be covering during this course, like defamation, assault, other than normal employment discrimination, retaliation type claims, a lot of what's called common law claims, breach of contract, fraud, that kind of, those kinds of things. We immerse ourselves in those kinds of claims, and many of those types of claims we'll be discussing during the course. Counsel thousands of people over the years. I've chaired many litigation or many trials. I would probably say over 100 jury trials, not just in the Virginia area, in the federal and state court, but elsewhere as well, mainly in this area, but in other parts of the country as well. We'll be covering many of the topics that I litigate or have litigated in the past, which is one of the enjoyable aspects for me in this class, and hopefully for you, because one of the benefits of having someone who's kind of in the world and has been in the world, not of academia, but actually in the practice of law in the United States, coming to teach, I would think is an advantage, because part of what I like to do when I teach the course is to try to incorporate a lot of sort of the practical, down-to-earth aspects of American law, and not just from an academic standpoint. We'll do that too, but also immerse ourselves a little bit more in the actual practice of law here in the United States. Okay, that's me. What I'd like to discuss more of is some of this understandings, themes, appreciations that I would like to see students walk away with at the end of the course. And these are themes that are going to show themselves throughout the course in various contexts. And orientation is kind of a good time to talk about sort of the overall global themes that are going to be running throughout the course. First, as the graphic shows, is hopefully an appreciation for what I would call the miraculous multi-layered system that the United States has developed over 230 years of history. And it really is multi-layered. The United States is broken out into a system of federalism, where it has a central authority in the federal government, which is further broken down, creating national laws, federal laws, and then each of the 50 states of the Union, each having their own constitution, their own legislatures that pass laws just for the people in that state. So one central authority, 50 subordinate, or I wouldn't say subservient, but subordinate authorities. It's an interesting system of federalism. It's not unique to America, but it is unique to the extent that it exists in America, given the number of years that it's been around. And also the legal system that the United States has had in place for the past 230 years for resolving conflicts and disputes for a population today that is more than 330 million. So it is a miracle in a constitutional sense that it's been around that long and long. Second would be an appreciation for the founders of this nation, although they were not without their glaring faults, as we will see in this course, but 55 of whom gathered in the hot spring and summer of 1787 in Philadelphia, Pennsylvania. They huddled together in Constitution Hall. If you ever have a chance to go to Philadelphia and to walk through it, you can take tours. They've renovated it. It's not old, but it's worth going to. But they were there, 55 of them, most of them lawyers. Lawyers created this country. 55 of them about during the hot summer, particularly in July and August, as we know, to hammer out and compromise the fundamental charter of the country, which is the Constitution of the United States. All laws, all American law begins with the Constitution of the United States. And that itself started from 55 men, because back then it was only men who participated in these kinds of discussions, in Philadelphia in 1787. And I would say that it has been unparalleled in human history to the extent of the complexity, the constitutional complexity of the American legal system, and for the duration, for how long that it has lasted, for over 230 years. It has stood the test of time over those 230 years, a civil war, which almost split this country apart. One of the blessings of this country's civil war is that it gave birth to the 14th Amendment to the Constitution of the United States, something we're going to be doing a bit of a deep dive in, because it's one of the heavyweight amendments to the Constitution of the United States. But it survived a civil war, it survived a worldwide and domestic depression in the 20s and the 30s. It survived 2 world wars in the 20th century. It survived a civil rights movement in this country, primarily in the 1960s. Many of the Supreme Court's decisions came out of the civil rights movement in the 1960s. We'll be covering those. And even pandemics, most recently, and also in the early 20th century. This isn't the only pandemic this country has ever had, or the world, for that matter. The Constitution of the United States has been able to survive all of this. But, as the graphic says, it's vastly different, vastly bigger, larger than the framers, the founders of this country ever envisioned. Much larger. And we'll be taking a look at that. The founders, in fact, their vision was of a limited national authority making laws, limited, and that most of lawmaking would occur by the states. Of course, back at the establishment of the Constitution, there was only 13 of them. Today we got 50, plus territories, and 11. But the founders' original vision of lawmaking powers for the 3 branches of government, because that's where all law comes from. This is not a political science class, so we're not going to delve too much into the structure of government, but the structure of government is necessary to be included in the conversation, because that's where all laws come from. And at the federal level and at most state levels, legislative, executive, and judicial, laws coming from each of those 3 branches of government, and how over the nation's history, over 230 years of it, lawmaking powers have been expanded by certain legal doctrines that we will take a look at in the course, because those have been the drivers of how big the lawmaking machinery in the United States has gotten from 1787 to 2023. And these doctrines we will talk about: the judicial construction of the words in the Constitution, the Supremacy Clause. There's a clause included in the Constitution which said federal law is supreme over state law, which effectively, from a constitutional standpoint, made this country a nation, as opposed to a federation of states. The Necessary and Proper Clause, which gave rise to the doctrine of implied powers. That Congress has powers to pass law that are not just explicitly stated in the Constitution, but implicitly stated in the Constitution, and the doctrine of incorporation, as we'll see. A doctrine where the Supreme Court started taking bits and pieces of the Bill of Rights that allowed for individual freedom and liberties in this country and began applying them directly to the state. Great expanse of lawmaking powers. And of course, we'll be covering all of this. Another theme that you will see in this course is, despite the title of the course, Introduction to U.S. Law, it gives the impression that there is one U.S. law. There is no one U.S. law. There is no one American law. Law comes in various forms and from various sources. It comes in the form, most importantly, from constitutions, both at the federal level as well as at the state level. Each state has their own constitution. The fundamental charter of the United States or the fundamental charter of a state. So the law comes in the form of constitutions. It comes in the form of statutes enacted by legislatures. It comes in the form of executive orders signed by presidents and governors of each of the individual states. It comes in the form of regulations issued by administrative agencies, which are itself the creation of Congress. We'll be devoting an entire class to the subject of administrative law, kind of the fourth branch of the American government. Decisions by judges. The judicial branch of government issues decisions, which has the force of law, and also we'll be spending a little less time on this, but treaties with other countries. When the United States enters into a treaty with another country, it has the force of law in the United States, just like any other law. So the law comes in many different forms, and we'll be taking a look at those various forms. All of this is occurring, as I said earlier, within the structure of federalism. One central authority, the federal government, 50 subordinate state governments, each with their own set of laws. This course will discuss how does all of that work? How does all that patchwork work? One central authority, back at the origin of this country, was 13 states with their own governments enacting laws. Now it's 50, and has been for some time. How does all of that work? Are some laws more important than other laws? What if the federal government passes a law that's in direct contradiction of a state law? What rules? What governs? And who makes that decision? Of course, we'll talk about that. And we'll discuss this and hopefully answer these questions. And the reason why I say hopefully is because of a couple of other themes that you'll be seeing throughout this course. One is the law is not static. The law is an evolutionary being. It moves slowly, but it does move. The law is not static. It evolves over time, along with the country's history. Of course, we've had 230 years of it. And also, the law doesn't always provide clear answers to the questions of the day. Lawyers know that. I see this in my own practice, where clients come to us, potential clients come to us, and they present their problem, and sometimes they have to be told that the law does not provide a clear answer to their question. This is the same at the level of the Supreme Court. We're going to be covering anywhere between 50 to 55 US Supreme Court decisions, not all in depth. Some will just pass over, but some in depth. We'll be covering 50 to 55 Supreme Court decisions. And you will see that many times there is not agreement, even among the experts in the law, that there is much disagreement, particularly in certain pockets of law. And one particular pocket that we're going to be taking a look at is the Due Process Clause of the 14th Amendment. That has two parts, as we'll see, procedural and substantive. Substantive due process is where the abortion issue is being played out. That's where invasion of privacy issue, whether or not the Constitution recognizes the right to, that the government not invade your personal space. That's where that comes from. And we'll see that there is great disagreement among even the experts, the justices of the Supreme Court, on that particular issue. And of course, it'll be very interesting to hear your views on whether or not the Due Process Clause allows for the recognition of fundamental rights that are not necessarily expressed in the Constitution. But the point for this orientation is that one of the themes that you'll see is that many times the law does not provide clear answers to the questions of the day, that there is room for argument, including at the level of the Supreme Court. I covered that. The last three themes, the last couple of themes of the course that you'll see are these. Individual rights and individual liberties, particularly if the government, particularly the federal government, is trying to infringe upon individual rights and individual liberties. A judicial system which has been created to try to enforce those rights, and also a judicial system, a legal system that has been created to try to settle disputes non-violently through an adversarial form of justice. And we're going to take a look at each of these. Individual rights and liberties, where do they come from? Can the government infringe upon them? What is the judicial system? What is that? What is it? Oh, that's nice. Nothing like an orientation being disrupted by a tornado. A judicial system that is designed or created, does that mean we have to do anything?
It's the weather service.
It's just the weather.
But we can stay here. I'll trust your word for it. Okay. That's probably true. I do see it's pouring outside. Okay. All right. So individual rights and liberties, a judicial system that has been created to try to enforce them, particularly when they're being infringed upon by the government, and also a system for resolving disputes in a non-violent fashion. It starts with the Bill of Rights. The Constitutional Convention was in 1787. It took a little while for the various states, there were only 13 of them at the time, to ratify it. Part of the deal that was worked out on ratification was that there would be an automatic 10 amendments that would be immediately appended to the Constitution of the United States, which occurred in 1791. And that's where all the individual rights, individual liberties are found. Because the concern at the time, it's nothing that we take it for granted today, but back then, this creation of a federal government was a scary thing. And there was nothing in the Constitution that necessarily guaranteed individual citizens from their rights being encroached upon by the federal government. So many of the states said, you want us to ratify this Constitution? You have to promise that you're going to immediately put in place 10 amendments. Actually, they were proposed at 12. It ended up being 10. To make clear that the government may have this authority under the Constitution, but not in these areas. These areas are protected from governmental intrusion. We'll be talking about that. And some of them include what you see on the screen. Some of them we're well familiar with. The right to free speech, the right to freely think what you want to think, the right to freely express yourself, freedom or free exercise of religion, or the freedom not to exercise any religion, which was a big issue, which is one of the reasons why many people came to this country, free from unreasonable searches and seizures by agents of the government, meaning law enforcement. The right to a fair trial, what does that mean? The right to counsel, the right not to incriminate yourself, the right that all of us have not to help the government throw ourselves in jail, the right against self-incrimination. And what has the Supreme Court said on these various rights? And also appreciation for the fact that these rights are not absolute, that these rights have limitations to them. And what we'll see, one of the major themes you see, of course, is at least American society trying to figure out what that right balance is between an individual right or liberty and the limitations that are placed upon it. And a lot of the stress and strains that occur, including at the Supreme Court and elsewhere, is basically to find that balance. The balance between the individual right, like the freedom of speech, and what the limitations are. For example, if someone took a bullhorn and went outside your home at 3 o'clock in the morning and started expressing their views, do they have a right to do that? Is the right to speech absolute? We'll be covering a lot of these kinds of questions and seeing how the courts in particular, and the legislature, the Congress as well, has dealt with these issues. We'll also walk through what a civil lawsuit looks like. We're going to learn in the very first class, the American legal system has two big divides: criminal, civil. Criminal, law enforcement, prosecutors, accusing you of committing a crime where it can ultimately lead to a denial of your liberty from a constitutional standpoint. Denial of your liberty, throwing you in prison. That's the criminal side. Then there's the civil side. That's the civil side I work and have for many years. What does that look like? What does a lawsuit look like? Who's filing these lawsuits? It's private citizens. What are some of the procedures and some of the rules? What kinds of claims can litigants assert against one another? What's the role of judges in civil lawsuits? And particularly, what's the role of juries? Has anyone ever served on a jury? I haven't either. I one time volunteered, and they laughed at me. I wanted, because I litigate in front of juries. I've met with juries after trials. But I've never sat on a jury. I almost got close, but I got excused, I think because I'm a lawyer. But special appreciation for juries. Many people in the United States tried to get away from jury service. And I argue strenuously with that. It's the most democratic form of participation in your legal system. There's nothing more democratic than to have whether or not you get thrown in jail decided by a representative sampling of your peers, you and me. There's nothing more democratic than that. Never could understand why people wouldn't want to serve on juries. Special appreciation for juries, as you can tell. So, welcome to US law. I hope that you will gain, not just sort of a working knowledge of how the system actually works, but hopefully an appreciation for the trajectory, the progression that the legal system has taken ever since the founders met in Philadelphia in 1787. Nearly 2.5 centuries of existence. It has governed the lives of hundreds of millions of people, though as you'll see throughout this course, not perfectly. Okay? That's kind of an overview of some of the concepts. Wow, it's really raining out there. Some of the concepts and some of the understandings that I hope that you walk away with come class 12. Okay? All right, some of the more mundane stuff. Syllabus. Does everyone have it? I see a head shaking. Okay. It should be, as I understand it, the school should have posted it. I've posted it on our Twin account, which I'll get to in a second. Okay, so the syllabus is posted on Twin. Like I said, I'll get to that in a second. Take a good look at the syllabus when you get it, or if you already have it. The syllabus is kind of an orientation onto itself. It provides sort of an overview, another overview of the class from classes 1 through 12. And if you just sort of read through the various topics, you'll see that one of the beauties of this class, one of the reasons why I like it, is that while we'll be doing some deep dives in certain areas of the law, it's a swath of the law. It's a smorgasbord of the law. We'll be covering anywhere, 12 different subjects under the law. So you'll get sort of a taste of sort of a representative sampling of American law. Of course, we can't cover everything in 12 classes, but we cover quite a few. Constitutional issues, criminal issues, civil issues, and all sorts of subjects, administrative law, First Amendment stuff, 14th Amendment. It's kind of it's a survey of the various. I want something later. Have to mute yourself.
What?
It's a survey.
Yeah.
It's one of the beauties of class. So take a good look.
Refrigerator.
The Twin.
Yeah.
Is everyone on Twin?
Not yet.
Okay, not yet. Okay. Twin is the bulletin board. It's basically a bulletin. So it starts. It's the bulletin board for the class. It's the platform that's used for the class. I use it mainly for one purpose, and that is I post, as you'll see, one of the ways I teach is by PowerPoint. Oh, wow, okay. And so I post the PowerPoints after every class so that you'll see it. Not before the class. Some have asked, can I see it before the class? No, there's reasons, we can discuss that. But after the class, like literally the next day. So you'll have a nice listing, you'll have 1 PowerPoint class, 2 PowerPoints, 3, 4, down to 12. So it's where the PowerPoints are posted. If you need help, the man I was speaking to before the orientation, I don't know if everyone's here, Pete Day, just email him. There's his email address. Just email him, and he'll set you up. Okay? He's my go-to when it comes to Twen stuff, and he's been very, very helpful. He sets up the page and all of that, and will help students connect to Twen. Okay? And when you get to Twen, the only thing that has been posted so far is the syllabus. So that's another reason to sort of get on Twen. Certainly, if you have any questions, you can ask me about it, but chances are I'm going to refer you to Pete. Okay? That's Twen. Okay. LLM class. Do you know what day we're meeting? That's JM. LLM. Wednesdays, show up on the right day. Wednesday, 6:05 to 8:05. Okay, 2-hour class. It's in this room, 215. I don't know if they're going to set it up this way. They didn't set it up this way in the past. I don't know if they're doing it just for the orientation. I'm not so sure this is as conducive. Let me talk to them about that. It was more of a classroom where everyone's facing, unless you all like it this way. But some have to turn around and kind of write on their lap. To me, it's not as conducive. But anyway, I'll find out more about that. So 215, this room, 6:05 to 8:05. Please show up on time. Please show up on time. So we can sort of get started, on time, or a minute or 2, 3 afterward. Don't abuse it. Don't come 10 minutes late. Just come on time. It's been an issue in the past with some students. Also, if you could do me a favor, and that the first day you come, the seat that you pick, if you could stay in that seat, because I have a chart. It helps me to get people to get to know people if they're staying in the same place. So I would appreciate that. For the JM class, Mondays, 7 o'clock to 9:55 p.m. The Zoom invite will go out shortly, and same goes. Please be online on time. Okay, it's just things go better when we're not waiting for students to show up. The readings. The JM class has 2 books. The LLM class has 1 book. Okay. The readings, which are all detailed, class by class in the syllabus, including for the first class. There is reading for the first class. Sorry, but there's reading for the first class. In terms of getting the bookstore should have them. The book, if you're LLM, the books, if it's JM, are in the syllabus. They're right there. The bookstore, I'm told, should have them. So get them from the bookstore. If for some reason the bookstore doesn't have them, just get it online. Either way, JM get 2 books, LLM get the 1 book. The syllabus indicates what the readings are for each of the classes. It breaks it out by pages. You can't miss it. The readings obviously provide more detail, more color, more background information that can ever be covered in class. The Burnham book, for example, is one of the leading textbooks in the country. It just came out with the, I forget what edition it is now, 7th, I can't remember, but like last year, so it's really current. But it's got a lot of information in it, and it provides a lot more background detail than ever could be discussed in class. The readings can help with the exam taking, which I'll get to in a second. But as the graphic says, do not agonize over every detail that you're reading in the reading. The reason why I say that is because the second time I taught the course, a student was in front of me, and she had all these notes. And I said, where are those notes coming from? Because I didn't see her take the notes in the class. And she said that these are the notes that she was taking from the readings, and the notes were like this thing. And I said, oh my goodness, I had no idea that students would be doing that. So the readings are there to provide lots of color, lots of detail than what can be discussed in class. But don't agonize over the readings. I'll get to exam taking in a second. But just get a flavor of what you're reading. Or if you read something you want to come to class to ask a question about it, that kind of thing. But it's not as if you're going to be tested on every single thing. I felt so bad for it. And from that point forward, I always alerted students that the readings are there, to help. They're not there to torture you, or not to take up every single, minute of your day. Okay? So the readings should be done in context. They provide lots more information than I could ever provide in class. And the like. But don't agonize that you think you need to know every single fact that you're reading in the readings. Does that make sense? Okay. How I teach PowerPoints in class, I post them on Twin the next day, so you have them. I strongly encourage discussion. I don't want this necessarily to be a lecture. I can if you want it to be, but I much prefer discussion, questions, being interactive, particularly with LLM students, because you come from countries where perhaps the legal systems are a bit different or even similar. It'd be nice to know that. It'd be nice for fellow classmates to know that. So strongly encourage discussions, questions. Sometimes I'll need to sort of keep the conversation going so that the material gets covered, during the class. But strongly encourage discussion and questions. I don't take sides on issues. Students sometimes will ask, well, what do you think? Where do you think the Supreme Court should come down on this? I'd rather not say. I don't see that as my role. I see my role as facilitating, of letting you know what the arguments and contentions are on both sides, and then you tell me what you think. I much prefer to teach that way. So students will walk away not knowing how I feel about matters, and I'm perfectly fine with that. I want to know what you think after the arguments and the contentions are on a particular issue, particularly contentious issues, are presented, and the like. Also, as the last bullet says, I don't call on students involuntarily. I know students sometimes have a fear of that, like you're a first-year JD student in a class of 200, and in property or contracts, and they call on you, and all eyes are on you. I don't want this class to be about that. So I don't call on students involuntarily. I think they call it the Socratic method. I remember how terrified I was 100 years ago when I was in first year law school. I didn't enjoy the feeling. I didn't enjoy going to class. I want you to enjoy coming to the class. I'd like you to participate though. And for those of you who are shy, for those of you who don't like to speak up, use it as an opportunity in a friendly, supportive environment to speak up. To speak up. Even if it's just a question and the like. Some students have an issue with that, being able to speak up in class. Well, use this as an opportunity to get better at that, to realize that there's no fear in it. There's just no fear in it. And a lot. So no, I don't call on students involuntarily. I'd rather it be sort of a voluntary discussion, and so make an effort to kind of speak up in class. Okay. Here are grades. It's in the syllabus once you get it. 25% class participation. Another reason to speak up, because it's 25% of your grade. Look at it that way. 30% is for the midterm exam, which is given right at the midway point. So it will cover classes 1 through 6. It will be closed book. It'll probably be in this room. and it's closed book. So it's you and the exam for the midterms, 30%. Just classes 1 through 6. And then after the midterm, we go from classes 7 through 12. That's the final. So the final will not be classes 1 through 12. Okay? That's too much material. I think that's too much material. So the final will be classes 7 through 12, the second half of the course. Okay? That will be open book. And it's okay if you don't get every detail at this point. We'll be discussing this obviously throughout the course. But that will be open book, and you'll have a 6-hour period online to take the exams. It'll be, both exams will be sort of a mixture between multiple choice and essay/short answer. Okay? And and the final exam is 45% open book. So 25% class participation, 30% midterm exam, closed book, 45% for a final exam, open book. The reason why I do 45, the reason why I weight the final exam a little more is because you should be more versed at that point, right? You've gone through all 12 classes by that point, plus it's open book. And by open book, the definition of open book is that you have access to the book if you're an LLM, the books if you're a JM, the PowerPoints, and whatever notes you took during the class. Nothing else. Can't go on the internet. Okay? Does that make sense? Yes?
Real quick question. Are the exams going to be during regular course hours, or are they going to be during working hours?
The midterm will be during regular course hours. You'll see this on the syllabus. So it will be from 6:05 to 8:05 during the normal Wednesday night class. That's the midterm. The final exam, okay, and it's okay if you don't get every detail about this. I do a 2-week window. And during that 2 weeks after the class, you can select any 6-hour period you want to take the final exam online, open book. Okay? So the answer is a little fudgier on the final exam because it's a 2-week period during which you can pick your own 6-hour time. Okay? Yeah.
And the final exam is to be done online here at the school, or can you?
No, it can be done at home. Right. Midterm will be here in class. Final exam at home, 6-hour window, open book. Yeah.
This is for both the JM and the LLM.
Correct.
So the JMs are expected to come in. Even if we're online, the class is online.
Good point. The midterm for the JM, that's a good point. The LLMs for the midterm will be here. JM is entirely an online, it's a Zoom class. So the midterm for the JMs will be also online. I'm glad you pointed that out. Okay. We will have study sessions before each of the exams. They're not on the syllabus because I try to accommodate people's schedules, and I don't know what their schedules when I do the syllabus. And they're recorded for both classes, so that if you can't make the exam session, it is recorded and posted on Twitter. And I always suggest that even if you did attend, watch it again. It's a great study tool, because during this study session, I basically give sort of a thumbnail sketch of classes either 1 through 6, if it's for the midterm, classes 7 through 12, if it's for the final. Okay, I give sort of a thumbnail sketch of the material that we covered and is likely to be covered on the exam. And of course, you can come and ask any questions that you want. And then it's recorded and it's posted for both LLM and JM, and you can see it anytime you want as you're preparing for this. Okay? My philosophy on exams is no gotcha questions. I'm more interested in whether students walk away with a clear understanding of sort of the large concepts of the class. Sort of the large understandings, the large concepts of the class. So there will never be a question that says, you know, on page 237 of the Burnham book, what did he say? It's not going to be that way. There's no gotcha questions. It's questions that are designed to test to see if students have been keeping up with respect to the sort of the large concepts of the course. Okay. How to succeed in the course? It's these 5 things, right? Come to class on time. Come to class on time. Actively listen during the class. Take whatever notes you think you need to take. Participate in class, either with observations or questions. Keep up with the readings. Keep up with the readings. It provides a rich amount of background information. And if you keep up with the readings, and particularly before you come to the class that discusses that particular subject matter, you'll be that much in a better position to understand what's being discussed in class. You may also have questions. Study the PowerPoint after posting, when things are kind of fresh in your mind. And also attend the exam study sessions, either live, in person, or whether you watch them on recordings. And like I said, even if you've attended, watch it more than once. It's a great study tool. So these are the various ways. Actively listen during class, participate, keep up with the readings, study the PowerPoints after they're posted, and attend the study sessions. Last but not least, my door is always open, and I really do mean that, okay? I don't have office hours. I don't have an office, hence no hours. Just email me. Just email me if you're struggling with something, if you have a question about something. Don't be afraid to email me. And email, which is on the syllabus, and it's on the front page. I'll be posting these PowerPoints as well. It's on the first page of the PowerPoint. Email is the best way to get it. Okay, sometimes I've gotten afterwards on the phone with students, sometimes Zoom with students, and the like. So if you're struggling with something, you don't understand something, email me. Many times what has happened is that students will email a question, but they only email me. I respond to it, then I ask the student, can I post this to the class? Because chances are if you've got a question, someone else has the same question. And then if I get a yes, because I want to get consent from you that I can do this, I will then post it to everyone in the class. Look at the question and the answer below. It's a way to help. I generally do global emails. So after I post PowerPoints on Twen, I'll send a global email to everyone in the class that, hey, the PowerPoints for class number 4 are up on Twen, just wanted to let you know. Sometimes I'll follow up with something that's been discussed in class, that kind of thing. And then usually I give like a blurb on what we'll be discussing in the next class. Okay? So my door is always open, and I really do mean that. Don't ever think that you're putting upon or that there's no time. I respond really immediately, particularly to students. If they have any issues about the class, any questions about the class, something that they're struggling with, just email. And we potentially could resolve it on emails, or we can get on the phone or on Zoom. Okay? All right. Can't wait to get started. I hope you too. And any questions about anything, either on substance or logistics?
If, for example, during Monday class and Wednesday,
The JM classes generally are recorded because there's Zoom. LLM is not recorded because it's considered to be by the school, not by me, but by the school, to be a live classroom experience. And if LLM students or even JD students, if they realize that everything is being recorded, they would never show up to class. They would just, watch the recording on Twen or whatever the platform is. JM is totally Zoom. So the classes are recorded and they too are posted in case you miss it. Now, there was some instances, I think last semester, where an LLM student couldn't, for some genuinely, legitimate reason, couldn't make it to the class, couldn't make it to the LLM class. And there were some instances where perhaps I could share with them the JM recording for that class. Now, it's different because the JM is a 3-credit class, so there's more material is covered, there's more readings, and so there's more on the JM recording that an LLM needs to know. But nevertheless, it was helpful for some LLM students that happened, okay? That's kind of a relatively rare event because the school requires LLMs to show up in class. And technically, if you don't show up in class, I'm not so sure that Zoom recorded, I think I got permission to do it. But for 2 of the students, I went ahead and shared some of the JM recordings because they genuinely couldn't make the class because of a family situation, a sickness, that kind of thing. So JM is recorded and posted along with the PowerPoints. LLM is not because it's considered to be a live situation, okay? That answer your question? Yes. Any other questions? Okay, guys. My email address is, I'll post this on Twin. Get with Pete to get on Twin. My email address will be there. And if you have any questions in terms of startup stuff, I'll do my best to help you. But I may refer you to other people because they're in charge of logistics and the like. But anything substantive, I can certainly answer. And the syllabus is on Twin. Okay? All right, guys. Can't wait to get started. All right.
All right, everybody. Everybody awake? You got energy? All right, that's good, that's good. So, all of the required sessions for today are complete. However, if any of you have questions about career services, especially important if you are an F1 student here and you're thinking about where your career is going to go after you graduate, I highly recommend sticking around. We have a career counselor who is a former LLM student with us who went through the F1 process here and now works as an associate over at GT Law. So he's going to be here to basically tell you his story. You do not have to be here for this. It is optional. It is not required. If you're a JM student, this might be relevant to you. It might not be. You're welcome to stay. If you decide to leave, have a great night. Have a safe drive home. If you decide to stay, he will be here in about 20 minutes or so. 5:30 will start. Until then, take a break. Okay? All right, great.
Thank you.
Thank you, Brian, for.
Thanks so much, Professor Sloan. Appreciate you
Sure.
coming out.
You got it.
Yeah.
Yes. How many credits did you register for?